Testing, 1, 2, 3. Can everyone hear me?
Good evening, everybody. So what we're going to do to start with, we're just going to take care of a little housekeeping here. We've noticed that when we talk through masks and so forth, that sometimes it always doesn't come up on video. So what we'd like to do, see, it's reminded me, I have it still not. So if you want to be heard, maybe it's best that you grab your mic, put it right up to your mouth and talk. If you don't mind, that'd be great. It's great to see lots of people here. This one's gonna be a little bit different than the other ones. We're here to learn. It's rather going to be probably rather boring. Well, no offense to the attorney, but we're here to learn. And why this is because we have new members. We have folks that like to have refreshers of certain things that we go through. We have people that have been around for a while that maybe need to understand certain elements. Plus the law changes. We just had recent standards changes. So that's why we're calling this meeting as a training meeting. We're not going to be getting into past, future, or anything like that. We're going to be talking about just as it applies to the law, which is the role of the Board of Adjustment. And we're glad you're here. We'd like to start this off first with a moment of silence and a prayer.
The chairman has asked me to break the moment of silence for the public prayer, so let's bow together in prayer, shall we? Father, as we come tonight to consider things that are very important to people's lives, we ask for two things. Number one, that you would give us a sense of oneness and peace and joy and working together in unity. And secondly, Lord, I pray for wisdom, how we need wisdom to judge righteous judgment. To be with us tonight and help us. We pray it in Jesus' dear name and for his sake. Amen.
The second item on the agenda is whether we have a quorum. I'm proud to say we have every member of the Board of Adjustment here tonight. And I'm glad. That shows dedication and I appreciate it. Because if you live here, you want a fair shake. You want to be able to live here in peace. And that means everybody. And so that's what our goal is. Our goal is to interpret the law. Opinions are fine, but we have to make our decisions on the law. And that's what we're going to discuss tonight, the law. Specifically, as mentioned in the agenda, it's going to be specifically about setting forth subject, time, and place. The consideration of any time limits for meetings or not. And second is the deep dive into the quasi-judicial process and specifically about special use permits. So do I hear a motion to accept the agenda? Okay. Approval of the minutes from April 28th. Second. Okay, we're done. Okay, so the first part, we're going to introduce our speaker for the evening. Where are you hiding? Can you maybe stand up and introduce yourself?
Yes, my name is, can you hear me? Brian Golden. I'm attorney with the law firm of Van Winkle in Asheville. I've been doing these types of matters representing municipal boards and dealing with special use applications, variants, and appeals for 20 plus years. And so I will be assisting this board in the unfinished business that is the training related to quasi judicial hearings.
First item of business. Public hearing.
Consideration of any time limits or meeting or presentation of evidence. So would you like to?
Yeah, Mr. Chairperson, the Board of Adjustment Rules of Procedure that were adopted back in 2015 outline the process by which this board would set a public hearing. And public hearing, as it's defined in the rules of procedures, is not limited just to quasi judicial matters, but to all matters that would come before this board. And so the public hearing will need to be set for upcoming matters that have been applied for. And so this, I think we submitted a proposed motion, but this would be the time for the board to consider setting the public hearing on the proposed date of September 23rd at the proposed time of 7 o'clock at this location, the Town of Montreat Town Hall. The rules of procedure also give this board the ability to set certain time limits, and those time limits are important so that everyone knows at the beginning of the hearing when it will end. That doesn't necessarily mean that the case is over. It just means that after 3, 4, 5, 6 hours, whatever amount of time you all want to dedicate on a particular night, that means it would be over. So for instance, if the matters come on at 7 o'clock and you say we are limiting all testimony, any amount of testimony, to 4 hours on that day, everyone knows that at 11 o'clock, it's going to be done. If the evidence is not complete, then at that public hearing, we can announce a date and time certain for the resumption of that hearing. And the individuals that are still participating can come back and continue their case. And so that's why we put that in there. I'm not familiar with the matter that's coming up, the special use permit, but I understand, and I've been contacted by several attorneys. And so with 3 or maybe 4 attorneys being involved, I suspect it may take longer than a night of hearing the evidence. And so that would be something I would ask the board to consider.
Let me ask a question then. At that hearing, one of the qualifications. That the person's extra testimony, what are the parameters for speaking?
Sorry, could you speak into the microphone just for the purposes of Zoom? Thank you.
Okay, what are the qualifications for speaking, or is it professional opinion? Who can speak?
That's correct. So we will talk about that at length at the training session as to who has standing to become a party, the rights that that party has once they're determined to have standing, who they can call as witnesses, who they must call as expert witnesses. And so we'll go through that process in the training session. And we'll also talk about the new statute 160D, which lays out what competent evidence has to be presented before this board and by whom that evidence must be presented. So that doesn't necessarily answer your question, but we'll get to that. And I suspect that there are going to be several individuals who will qualify as parties with standing, and then those parties are entitled to participate fully in the hearing. And that means They get to look at documents, they get to confront and cross-examine witnesses. They get to object to the board if there's any conflicts. They get to introduce their own evidence. They get to make arguments. And so, yeah, so the individuals with standing will be able to participate fully, calling witnesses, whether they're lay witnesses or fact witnesses or expert witnesses.
Sorry, how many lawyers have you said already have expressed interest in? You said 4?
Well, the applicants are going to have a lawyer, and I understand and have been contacted by 2 others, and there is potentially a third. So that would be the applicant's lawyer, 2 other lawyers that I'm aware of, and maybe a third. So that would be 4.
So 4. And are these people, will they be I mean, the lawyers, surely they'll be vetted. But anybody that wants to speak that night, will they be vetted ahead of time or at that night?
So we'll talk about that again
Again, okay.
in the training, right? We'll talk about when this board deals with that. But the lawyers that I know that are representing individuals already are competent lawyers. They know the process of standing. That process happens in front of this board. This board as a group would have to make a decision on who has standing and then can participate in the hearing. So I can't tell you right now who it is or whether they have standing or whether they're going to be able to participate. And this all goes back to setting a time limit. If this board doesn't want to set a time limit, you may be surprised that we'll be here till 1 o'clock in the morning with the lawyers saying, oh, let me just present one more expert witness who is from Florida that doesn't want to come back the next time. And this board will be exhausted, tired, and you have to give everyone a fair shake, right? So you have to be able to pay attention, listen to the evidence, because ultimately you will be the trier of fact and potentially weighing that evidence. So it is smart, in my opinion, to put limits on the length of time that you all will sit here as a board and listen to testimony.
If we could, can we talk about the first item, and then I'm sure we're going to have lots of discussion in the second item. I watched the tree board today, and I noticed that a lot of discussion was around when they were going to have certain events, when they were going to have to cancel, we're going to postpone. That could come up here because, you know, the most recent COVID things are. So I just want to say that we have a process in place where we'll notify if things change. And everybody will be notified in the way that we're supposed to be notified. But just keep in mind that their events could change. I also want to remind you is that there will be a lot of opportunity to talk, whether we take breaks in long meetings, whether we do continuances to the next meeting. I want to just, as we do in every meeting, remind everybody of ex parte communication, that we do not talk about this with any other board member, that you're basically under oath at that point. So I would like you to remind you that this might happen. I can't see us doing this in one night. Maybe if lucky, but I really saw it. I'm kind of foreseeing that there could be, and I could see that there's witnesses that will be coming in and testifying. So I'm not really, I don't really like to say, well, I want to limit this because that's going to say, well, the person that's presenting, I don't want to limit. We've got to have a fair hearing. This is an important issue. We've got to have a fair hearing on both sides. So whether we do that or not, we can discuss.
And I'm not talking about limiting anybody's ability to present evidence. I'm talking about putting a time limit on your daily, like, so if you come on the 23rd, you put a time limit on that. It doesn't mean that all the evidence has to be presented. You're just saying, ladies and gentlemen, an applicant and opposition at 11 o'clock, we're calling it a day. And if we have to come back to reconvene to hear more evidence, it's going to be at a date and time certain that you set on that night. So I'm not saying that you limit anybody's testimony to 2 hours to 4 hours. All I'm saying is you should limit the time within which you hear testimony on any given day.
That mean we have to start at 7 though. If we're gonna listen to hours of it, we're gonna listen to 4 hours. 11 o'clock is late. But for me, 11 o'clock is late. I'd rather start early in the day if we're gonna stay longer. But are we bound to 7 o'clock?
No, you're not bound to 7 o'clock. You all publish, and Alex, you can correct me if I'm wrong, but you all publish a monthly meeting that you have every month that starts on blank day, whatever it is, the third Thursday of every month at 7 o'clock. So if you're going to have your regular meeting, I think you're starting at 7 o'clock. I'm assuming the 23rd is the regular meeting. They would just have to send out notices advertising the new time. If you said, I want to set this time at 5 o'clock and have 6 hours of testimony still ending at 11.
No, I was thinking 5 hours. It's still.
But yeah, so if you weren't going to re-advertise, and I think you still have plenty of time, if you weren't going to re-advertise and just have it on your regularly scheduled hearing date, it would be 7 o'clock. But you can definitely send out notices that say that the hearing's going to be starting at whatever time.
That's the question. Do we have enough time to? Do we have enough time, Alex, to notify people if we change the time?
We haven't publicized the notice, the official legal notice yet for the 23rd. So we can adjust that before it goes in the paper, and then we can send it out in the Montreat Minute as well.
Does that make a burden for you and staff? Preference. Preference to start earlier or later?
I'll leave that to the board.
Well, let's discuss
Yes,
that as part of this agenda. So what time?
I'm good for 3 o'clock.
Any other
We
feed-
heard an applicant one time, and I remember that lawyer bringing up that it was a problem that we didn't meet on a regular day at a regular time because it had been published and was in documents and that kind of thing. Now, some people might say that's nitpicking, but I don't want it to be a problem.
So in this case, Alex, you have not sent out the notice, is that correct? Are you saying that it's a regular schedule?
Alex can send out the notice and advertise it at a different time. So if this board elects to do it at 5 o'clock, notwithstanding the fact that your regularly scheduled meetings are for the third Thursday of every month at 7 o'clock. And I don't know if it's the third Thursday, but whatever it is at 7 o'clock, you can still advertise it for 5 o'clock. And as long as you satisfy the statutory requirements of no sooner than 10, no later than 20, no later than 25, no sooner than 10 days before the meeting, then you've complied with the statutory requirements to notice
Chairman.
this meeting.
Since we are the students and he is the teacher, can I simply ask, what is your experience that's an optimum time to begin and continue and end?
So just based on, and these are just the last two hearings that I had a Mills River hearing that started at 7 and ended at 12:30. That was useless. After about 11 o'clock, it was, and we had to finish that night. And so everything was rushed. So 7 to 12:30 is awful. Do a lot of hearings in Henderson County. They start at 4 o'clock and they finish promptly at 8. So they limit it to 4 hours, which I think is completely fair. We've had a small little special use permit that I'm involved in, and we'll be going back for the third night of testimony next week, I think. And so that 4 hours might not be enough. I've had Madison County, they go 5 to 6 hours, and they start at 6. And so I've been in Madison County from 6 to 12. Again, that's a little too long. But anytime I would think between 4 to 6 to start, and then pick a time, I think anywhere between 9 and 10 terminating the meeting is good.
So this is Scott Adams, I'm the zoning administrator, just stating that for the record. I'll just quickly note that your current rules of procedure state the board shall hold its regular meetings at 7 PM on the fourth Thursday of each month.
An advertised notice, you can, if you're holding it on the fourth Thursday of every month and it happens at 7 o'clock, you're still complying with your rules of procedure. You can notice the hearing to come on at 5 o'clock. The notice provision is set forth in 160D. Well, and it might not be 160D. It says proper notice in 160D, and it probably takes you back to I don't know, 160A when it talks about advertising or noticing public hearings. But that's, you would be complying with holding it. And again, we're still here. That could be the regular meeting. If this board decides that it wants to put the meeting on a different date, it can set that date, advertise it properly, and still hold the hearing. And then if there's nothing to be heard on the fourth Thursday at 7 o'clock, it can cancel that meeting. So, I mean, we're here to talk about that, notwithstanding the fact we were trying to put it on the fourth Thursday of the month. We can set it, you guys can set it for any day, and as long as there's enough time to properly advertise it, we move forward.
Mr. Chairman, just to get things moving, I would like to suggest that we set a time limit of 3 hours at first meeting. Thought I was, I'm sorry. This is muffled.
Maybe a little bit closer.
Just to get things rolling, I'd like to suggest that we limit the meeting to 3 hours, no matter when we start and when we close. After 3 hours, the brain starts to shut down, even in lawyers.
I don't think that's quite long enough. I think we might end up having to meet 4 times if we only limit our meetings to 3 hours. I think it should be at least 4 or maybe even 5, considering everybody that has to be gotten together, including witnesses, lawyers, us, them. It's just a lot to get anybody together on one night.
Mr. Chairman, I'd propose we start at 4 PM.
In addition to starting early, and I may be jumping ahead, but is there a way to say, if we don't finish tonight in 5 hours, we can reconvene tomorrow night? Can we go ahead and set the next night just in case? Or are we going to have to wait another month? Do you follow me?
Yeah, you don't have to wait another month. The idea of setting the following day for a follow-up hearing probably wouldn't be advisable today. What I would do is set the initial day that you want to have the hearing. And if you start at 4, I think you said, and you at 10, you're still not done, you set on that date, whatever day you choose, you set a date and time certain to continue that hearing. Most often, individuals will, or most boards will continue it from week to week. So they'll have 1 week, not the next day.
Not the next day.
Not the next day.
Okay.
No.
Can
Yeah.
we set that ahead of time, or do we
No.
have to do it
I-
that night?
You can set it ahead of time. I would advise against it, because when you have 4 lawyers here, and then you've already set the hearing, you may have one that's on secured leave, which means they don't have to appear. You may have someone that has a trial that's already in conflict. So the best scenario would be setting the first hearing date. And then on that hearing date, if you don't finish, to take a poll of the board members, when they can be back, when the witnesses can be back, when the lawyers who are representing the interested parties can be back, and then set it on that day. I wouldn't try to schedule it
That ahead of time?
that far ahead of time, yes.
Okay, I would just, I guess, to all our board members, let's be available so we can move it through, as quickly as we can.
Okay, so we got a couple of things here. We've got no more than 3 hours. We got 4, starting at 4. We have to start coming to some conclusions here. So kind of our job to, that's part of the agenda.
We'll start with the day. Is September 23rd an appropriate day? All right, so we have that. And then, yeah, then think about the time in or when considering the time limit for testimony presentation on that particular day.
Well, I'm with Robert. I'd like to start early, 4 o'clock, if possible, 5, no later than 5.
Okay, so there's a motion on the floor to start at 4 o'clock. Any objections? 4 o'clock it is. Now, the time frame. We do need to come up with a time frame. I think that's right. So I'd suggest, meeting of the minds. I've heard 6, I've heard 4, or I've heard 3. What's the middle, 5?
I would say 5 hours with a half-hour break. Because if we're starting at 4, people are going to be hungry. People need a little bit of something. Is that possible to do that?
Oh, yeah, you can set any amount of time. Every Henderson County, for instance, when they start at 4, every hour on the hour, they take a 10-minute break.
So I
So,
would
yeah,
say
that's-
4 to 9 with, make sure that we're taking some regular breaks and nobody gets too tired or fatigued from this.
Okay, so we passed 4. And now we've got the time frame.
So moved, 5 hours.
I want to come back to your earlier issue. I realize we don't want to set the next hearing, but can we poll now and figure out if we're all available the next day or the next 2 days to have some framework for where to go? Because if you are an attorney trying to figure it out, you got to know you got to be in court or out of court. You can, this early, you can start to see where it's going, but also we just have other lives. And I know as we get in October, start.
So that's going to be entirely up to the board. I would advise against it, right? Because if you set those dates now,
I'm not saying set, I'm saying pull the board now to see if those are possibilities now. And we, in our schedule, can reserve it. We didn't commit to it. We just simply reserve it.
yeah, the board can reserve dates, but you will find if you get here and you say, okay, so September 23rd is the day that we're going to have this hearing starting at 4 for no longer than 5 hours of testimony. And then the board says, oh, and we can all be available on the 24th. I can guarantee you without a doubt that you're going to have somebody in that hearing say, I can't be here the next day. And so this board can do, if they want to do an informal poll and decide what dates are out there, we're really not that far. For all I know, some of these attorneys have trials set during that week. And so they may be coming from a trial and then jumping right over here into
But if
this
they-
matter.
But if they can't make it, are we obligated to adjust to their schedule?
So the obligation of this board is to be a fair and impartial trier of the facts. And so if they can't make it here on the date and time that you set, this board would entertain a motion to continue it. And based on the facts of that motion, would make a determination as to whether or not the matter should be continued. I will say I've talked to 2 of the 3 attorneys that I know that are involved and have already said, in all likelihood, September 23rd is going to be the first date for this hearing, for the special use permit application.
We're just about done with that first one. I've got a question about, you talked about time limits for the meeting. You also mentioned presentation of evidence.
That's the same thing, right? So the evidence that's going to be presented on that night, it's the time limit for the meeting or the presentation of evidence. I didn't know how this board wanted to consider it. And so you would allow 5 hours for whatever, opening statements, staff presentation, cross-examination, presentation of the applicant's case, their expert witnesses, their fact witnesses. After 5 hours, right, is that what we said, 5 hours? 5 hours, we're done. And everybody knows it. And then on that day, we set another day to come back that is agreeable to everybody. Again, we are here to be fair, listen to all the facts, let everyone present their case. We're not here to hurry it along and make a rash judgment.
More discussion on the first item. No more discussion. We'll move on to item 8. Standing quasi judicial hearings, order of process, presentation of evidence, quality of evidence, special use permits.
Yeah, and I'm gonna come to maybe bring my stuff to the center. I think that would be easier than craning my neck and have you all do the same. So I'm just gonna grab a chair. I'll just grab this chair. All right, as part of my preparation, I sent Alex what I call a protocol, and I believe you all have it in front of you. It's a 3-page document. It has some bold print with some red print. And it starts talking about introduction. So the Town of Montreat Board of Adjustment protocol for quasi judicial hearings, and in particular, a special use permit. The first issue, so, right, normally there's a brief introduction when the chairperson talks about what the application is, and I've written out a little kind of a script that the chairperson would say, and basically it talks about the hearing being a quasi judicial evidentiary hearing. You all act as you all would act as a court, right? Where you are admitting the evidence and qualifying or accepting individuals as experts, but then you also act as the jury if there is opposition testimony presented where you would have to weigh, and we'll get into it, where you would have to weigh the evidence. And so this just goes in and says a little bit about it. The quasi judicial evidentiary hearing is similar to a court hearing. There are specific procedures and rules governing how the board makes its decision. The board's discretion is limited. The board bases its decision upon competent, material, relevant, substantial evidence. It's made upon the facts presented at the hearing. It goes on a little bit to talk about in the introduction, witnesses and focusing on facts, standards, and not personal preference. Then it goes into party status. And I believe we already had a question about it. How many individuals are going to be able to testify and who can testify at this hearing? And that is determining party status. And I call it, and everybody else does too, it's standing. Does an individual have standing to participate fully in the hearing? And by participating fully in the hearing, right, they have the right to review documents, cross-examine witnesses. They have the right to complain about any conflicts this board may have in hearing the case, but they also have the right to present their case. They have the right to call witnesses, designate individuals as expert, and allow those experts to give opinion testimony. And so when you are deemed to be a party with standing, again, you get to participate fully in the hearing as if you are the, adverse to the applicant. But if you are the applicant has standing. And that's just, that goes without saying. The property owner, if it's different than the applicant, would have standing. And I indicated in my protocol here that the town staff has standing. It's not that they have standing, but they get to participate fully because they're the staff. They give you a staff report. And so the first matter that this board would do after the introduction, tells everybody what kind of hearing it is, what they're expecting to happen, is we as a board, and I'll just call us we would then invite individuals to present any type of testimony that they have as to why they would be an individual with standing in order to be made a party to the case. And I talked about in this protocol, evidence of standing may include proximity to the subject property. So you may have an adjoining property owner that says, I want to be a party with standing, participate fully in the hearing. And the evidence that I have is that I just adjoin the property. Well, just adjoining the property isn't going to be enough, right? There has to be something else. And so I think in here, we'll talk about it, but the mere fact that someone adjoins a property doesn't necessarily in and of itself give them standing unless they can show some kind of negative or economic impact on their property, the value of the property, the use and enjoyment of the property related to a particular aspect of the proposed use. And most of the time it's just generically thrown in, right? So proximity of the property to the proposed development isn't sufficient in and of itself, but if there are credible allegations that the use of the property of the proposed site would injure my property values if I'm the one seeking standing, and that injury is based on like traffic, noise, glare, parking, security, stormwater runoff, littering, that is what our Supreme Court of North Carolina has said is credible evidence sufficient enough to give a party standing. And so it's not it's not hard to be a party with standing, but it shouldn't be easy. It's not a generic, the use of the property is going to devalue everybody's property in Montreat or in make-believe town. That's not enough. It has to be particular to that individual. So if I get up and I'm a person and I say the proposed use in make-believe town is going to cause all of the surrounding properties in this block to lose property values, that's not enough. It's going to cause all of the surrounding properties in this neighborhood to lose property values because of noise, odor, and glare. Still not enough because it's not particular to the person seeking standing. My property values are going to be affected, negatively affected because of noise, odor, and glare. That may be enough. This board would consider a motion to approve or not approve that person for standing You vote on it, and then if that person has standing, they sit down, another one comes up and they say, I'm a property owner that lives, a mile down the road. Is that close enough in proximity? Probably not. But if they say, well, I live a mile down the road, and everybody that's going to use the proposed use has to access it across the back 40 of my land that has the easement, that is probably might be sufficient. And so this board will have to consider all the individual facts and circumstances of each individual person, whether it's particular to them, because it has to be particular to them, what economic effect it would have on the value of the property or the use and enjoyment of the property, and what is the reason for that negative effect, whether it's noise, odor, glare, traffic, littering, stormwater runoff. So it has to be right. And it's not that they have to prove it. They don't have to come forward and prove it. The cases in the Supreme Court just saying that there has to be credible allegations, right? And so what is a credible allegation? That's going to be up to you all as the fact finder to determine. And again, it's not difficult to have standing in a hearing, but it shouldn't be easy. You have to come forward. Some lawyers, and I do it myself, will just submit an affidavit and say, I, Brian Golden, owner of adjoining property, live at blank blank, have lived there for so many years. We have expert testimony that's going to be presented that would show there's a negative impact on the value of my property related to, and then just give a laundry list of what those things are. So sometimes it may just be an affidavit that is presented to you that you can look at to see. And again, I don't know how these lawyers that are going to be at the upcoming hearing, how they're going to do that. And so once an individual, and it may be 4 individuals, get standing, then they would be parties, their lawyers would have the ability to participate and act as they would in any court hearing.
So if
cross-examining
we
the-
had, let's say we had somebody that they brought in that was a subject matter expert. That subject matter expert, let's say they brought in multiple subjects. Do we vet that? We have in the past. We vet that person. If they haven't supplied documentation, then we ask them, can you tell us a little bit, like we did with you, can you tell us a little bit about your experience? Does that vetting process, or do you just accept it if they have some sort of?
So if I'm coming up and I'm John Q. Public, I live at the adjoining property. I've got an expert who is going to testify that my property is going to be negatively affected because of traffic. I have a traffic expert who is going to say that the increase in traffic is a safety concern. On all of those factors, I'm seeking standing. That probably is credible enough to allow that person to have standing and participate as a party to the proceedings. They don't have to prove it when they're seeking standing. They have to prove it so that if it ever goes up on appeal to a Superior Court or Court of Appeals or Supreme Court, that they have presented sufficient evidence. But to you all to make a determination, it's just that they have to have credible allegations that they will be affected or that they have standing. And so you don't need an hour's worth of testimony. It might come into that, right? Because then as the lawyer for the applicant, if I get up and say, John Q. Public, like I just said, the lawyer for the applicant might ask me some questions. And I might go, oh, I don't know the answer to that. I don't know the answer to that. And the lawyer for the applicant may have sufficient enough questions to cause you, board members, to want to hear additional evidence. And so again, you're not, if an expert gets up there, you're not saying, we're going to qualify you as an expert, go through your whole case study, give me the facts upon which you base your opinion, and then give me your opinion. To qualify for standing, you would just say, we'd like to hear from your expert. Can you have him come up here? And the expert may say, yeah, I'm an MAI appraiser. I've looked at the property, and because of noise, odor, glare effect, I will be giving an opinion that it has a negative impact on the value of John Q. Public's property. That should be sufficient to give standing, just to participate. You're not there to say whether or not that expert opinion is true, whether it's credible. At that time, all you are there to do is to see if that individual is an aggrieved party who suffers some kind of damage different from the rest of that community, right? And so if it is just someone saying the whole community is going to suffer, that's not enough. It has to be particular to them, right? That individual has to be an aggrieved party suffering special damages. And it's not that they got to prove it to you. It's just that as long as you deem the allegations credible, then you can grant that standing.
Well, I'm sure all the lawyers, 4 lawyers at a time, would all agree at once, I'm sure. So I'm curious if you've got attorneys talking back and forth that don't agree, then that's our job to try to figure out. Well, he said that, he said that. That's the tough part.
Yeah, and there are times that I have entered into stipulations where the applicant says, we will stipulate for the purposes of the hearing in front of the Board of Adjustment that your clients have standing. So we don't have to go through the whole process. We just have a stipulation. We just jump right in. The staff gives their presentation, the applicant does their stuff, and then the opposition does their stuff. It makes it easier on you. The parties in opposition still have to put forth sufficient facts so that if it's appealed on review, a Superior Court judge, Board of Appeals, Supreme Court justices can determine that they did have standing.
Right here, you have 3 things on evidence of standing. Proximity to the property, damage to property values, and secondary impacts to use and enjoyment. Those are 3 considerations, evidence of standing. Are
Yes.
there others? Especially that you mentioned North Carolina. You were saying something about noise or glare, or, I mean, is there a list of things that we?
No, there's no
No,
list.
no.
The secondary effects are the odor,
Whatever somebody
noise,
else
glare,
thinks.
stormwater runoff, traffic.
Whatever
could
someone
be-
comes up with.
Yeah, that's right.
Okay.
It could be anything. And so there is not a defined list of, if you join the property and your value of your property is affected by blank, you have standing. It is just an accumulation of all of that. But those are the 3 important elements that when you read all of the cases that talk about standing, it talks about proximity to the property, right? Whether it's adjoining, which is close, like it's really close, but you still could have standing and be, like a mile away, like I said, if all of the traffic is going to drive through your backyard on an easement to access a mini storage warehouse, and so then the secondary effects, you have to give the facts upon which you are claiming to be that aggrieved party. And that is the odor, light, noise, glare, smell, traffic, littering. I mean,
But all
anything.
3 of these seem to be premised on the fact that there's some property, a property owner, not someone that is a visitor to Montreat or a summer visitor.
You're
It's-
you're
this is-
exactly right on that.
Okay.
Yes. And so once the presentation for standing is made and this board considers, again, there would need to be a motion to either accept that individual with standing or to deny that individual for standing. And again, the property owner, the applicant, and staff all I'm going to say, have standing and participate fully. Again, the city staff or the town staff really doesn't have standing, but they are allowed to participate fully, be represented by council if they so desire. And so that is standing in a very condensed nutshell. I will say this, there was a case a couple of years ago, Cherry v. Wisner out of the North Carolina Court of Appeals that did say aesthetics. If someone says, I join the property or live across the street, my property values are going to be affected because that, whatever it was a house, is aesthetically unpleasing. That court was specific and said aesthetics are not sufficient for the secondary, right? We're talking here, the secondary impacts, aesthetics are not it. Now, they can be part of it, aesthetically unpleasing, and the glare from the floodlights are going to drive me crazy. Maybe that's sufficient. I don't know. But aesthetics alone was not sufficient to grant that opposition party standing. Yeah, and I was just looking at it. I've got a little folder with all of my standing information in it. And that case, the Cherry v. Wisner case, did say special damages for an aggrieved party in the presentation of their standing application includes economic damage such as decrease in the property value, other direct adverse effects on the property such as smoke, light, noise, vandalism. I left that vandalism created by the proposed use. Special damages would not include aesthetics alone.
You said aesthetics alone.
Aesthetics alone would not be sufficient if that was the secondary effects. And again, I mean, you can have aesthetics, negative aesthetics from I'm going to say mini storage warehouse, but I don't know that that's aesthetically unpleasing. It depends on where it is, but a roundhouse, that would be aesthetically, maybe to some aesthetically unpleasing in a historic neighborhood. That alone isn't sufficient. No, keep going.
Okay. If something refers to in the zoning rules, point to a document, says this is what, whether it's so we have to go by that language, because that kind of flies in the face of what you're saying.
So I'm not sure your question at all, but we're going to get to the standards that this board looks at. We're talking only about standing right now. And it has nothing to do with what has to be proven in order for a special use permit to be approved, right? That is, those are standards set forth in your ordinance. And we'll get to that, right? We're going to go to the quasi judicial process next, and then we'll go to the special use permitting and what standards this board has. And so if, for instance, what you're saying is let's say, for instance, the proposed use does have to have adequate ingress and egress to protect the safety of individuals using the facility. And what you're saying is someone comes up and says that adequate ingress and egress, I think this is what you're saying, that adequate ingress and egress is what's going to cause me harm. Is that what you're asking? How different?
Not exactly. I'm more asking the references to document says this is what like stone on our building, so we like, it's all, the zoning seems to point to that as a reference. It's just curious.
And then that goes to what I said earlier, just a second ago, we are going to talk about those standards, right? Because one of the elements that the applicant will have to prove is, look it up, it says it has to be in general conformity with the adopted policies and plans, including the comprehensive plan of the town of Montreat. Right, so that's an element that has to be proven by the applicant for this board to consider granting the special use application. But that wouldn't be used to say someone has standing. The individual who's claiming standing is particular to them. How is that use affecting me and my property? And what is it about that use that causes that adverse effect? Anyone else standing? Because if not, we'll move on to the quasi judicial process. So I just want to make it clear, standing is important, right? This board has the ability to allow at the end of the hearing other witnesses who don't have standing to talk and present evidence, competent material and substantial evidence, but you don't have to. Right? The statutes say that you may entertain other witnesses to offer competent material and substantial evidence, but you don't have to. You can limit it just to the applicant and those parties with standing. And I think you'll probably hear so much evidence, maybe too much evidence, that you may want to limit other witnesses to come forward and present, what they deem to be material, competent, and substantial evidence. But that's for the day of the hearing. We can talk about that. So standing's an easy concept, but it's hard to define. And so if you don't have any questions, we'll jump into the quasi judicial process. I think that was next on my protocol.
Can I quote you? That sounds like lawyer speak. It's an easy process, but hard to define.
Is a what process already defined?
You said it was an easy process, but hard to define. I said, is that?
Yes, and so the easy process is a lot of local governments will err on the side of caution. And if someone comes up with the credible allegations of, I live next to it, my property is going to be negatively affected because I can hear the gunshots that are going to be fired at the shooting range, a lot of local governments will err on the side of caution and say, you're a party with standing, you can participate fully. Right? But what it is that you're specifically looking for, you can't define it. You'll know it when you hear it. So quasi-judicial hearings, we talked a little bit about it in the introduction, right? In that little protocol, you'll read the introduction that talks about what the quasi-judicial process is, how this board acts, what this board expects to hear, and what I like in my protocol and my statements that the chairperson would make, I like to put in, right, the meeting is open to the public and everyone is welcome to watch. However, participation is limited to parties with legal standing. That's just a nice way then to segue into the standing aspect of it that we just talked about. But the quasi-judicial hearing is this board acting as a judge and the trier of fact. The idea is to to allow for the applicant to build its case and the opposition to oppose it, right? And you all then evaluate all of that evidence. And so the statute requires that the evidence presented before this board has to be material, competent, and substantial. We'll get into that, but in just a little bit. And that is for both parties. That would be for the applicant and for any other party with standing in opposition. And the material, competent, substantial evidence is what's used in the statute. Again, it's not necessarily defined. I've got some language that some folks smarter than me have put out, and some cases what it deems. And then in the statute, there is a term that, or there is a provision that says competent evidence is this. So we'll go through that. But the idea for you all is to build this record, to pull in all of the facts and evidence relevant to the application and or relevant to the opposition. If in general umbrella kind of view, if the applicant satisfies you with competent material and substantial evidence that it has met all of the necessary factors for a special use permit, you all would be required to grant it, right? So you don't have any discretion not to grant it, even if you don't like the idea. If you say that's a horrible idea, we don't need another dog kennel, we don't need another hair salon, so horrible idea. If the applicant has satisfied all of the elements by competent material, substantial evidence, you would then have to give it to them. However, if there's opposition and the opposition comes forward with what you deem to be material, competent, and substantial evidence, then you all balance that evidence. You during your deliberations, you would talk about the facts. You could, for instance, discredit an expert witness because maybe you feel he's biased or she's biased. Maybe that expert witness giving opinion about traffic lives right next door and has been vocal about not liking the use. And so you may go, that expert may be a little biased. And so when you're weighing the evidence, you may weigh the evidence more favorably in a favor of the other expert as opposed to the one who maybe has bias. But again, that is you all acting as the trier of fact. And so that's the idea, right? You've got to, it's not a burden of proof, it's a burden of persuasion. The applicant has to come forward with sufficient enough evidence, competent material and substantial evidence to satisfy all of those elements. And then in the next section, when we talk about special use permits, we're just going to go through those elements real quick because I can't tell you anything other than what's in your ordinance and that you have to follow it. But once the applicant satisfies its burden, it's up to the opposition to offer contra evidence. And then you all would be the triers of fact to weigh that evidence. I mean, it is truly just a weighing of the evidence. It should spark wonderful debate if there is material, competent, substantial evidence provided by both the applicant and the opposition. And so you would ultimately, once the hearing's closed and you start deliberating, you would need to talk about all of those issues. The other aspect of these quasi-judicial hearings, we talked about it earlier, is that one of the essential elements is that you all are to give everyone a fair trial. And that includes the opportunity to present their evidence. And if a lawyer or somebody in opposition says, I can't make it on that day, you all would have to entertain a motion and determine why or why not. Is it a justified reason to continue the case? But ultimately, if you're giving individuals a fair trial, and you want to build and evaluate the record, in all likelihood, you are going to make sure that everybody who has standing, including the applicant, can be at the follow-up hearings, because you need to build that record. The last thing that you want is someone to claim that you violated their due process by not letting them present their testimony, or that you cut them short in presenting their testimony. And so, right, those are the two things in this quasi judicial hearing that you all want to consider. Fair trial, I just wrote down some quick notes. All essential elements of a fair trial must be preserved. That is, you follow your applicable procedures, that you're impartial, you allow parties with standing to participate fully, and you base your decision on competent material and substantial evidence. And that the decision to be made based upon competent material and substantial evidence is in fact stated in chapter 160D 406, where it talks about every quasi judicial decision shall be based upon competent material and substantial evidence. And so when looking at Brian, what is competent material and substantial evidence? And I'm going to say generically speaking, it has been said by folks smarter than I that evidence is competent if it is sufficiently trustworthy and reliable and legally fit and acceptable for consideration by the board. So that's just as generic as competent evidence, but competent evidence would have to be sufficiently trustworthy and reliable, legally fit and acceptable for consideration by the board. And so you can think of things that would not be sufficiently trustworthy. I had a dream and this happened. That's not going to be competent evidence. Material evidence. Evidence is material if it shows that one of the standards to be applied will or will not be met. And that is, I think, easy. We'll go in and we'll talk about the standards, but if someone presents a case, whether it's through expert opinion or lay or fact witness testimony, the evidence would be material if it is designed to prove and or disprove one of the standards set forth in your zoning ordinance section 310.62. We'll get there in just a minute, right? So we've got competent evidence, which is sufficiently trustworthy and reliable. Material evidence is that evidence which shows that one of the standards to be applied will or will not be met. And evidence is substantial if it is relevant and something a reasonable mind would regard as sufficient to support a conclusion. Again, it's relevant and something a reasonable mind would regard as sufficient to support a conclusion. Again, that doesn't tell you much more than the word substantial itself, but it does say, and courts have held, and my notes reflect, that something is not substantial if it's just pure speculation or unsubstantiated fears or vague assertions, right? So if it's like, oh my God, I worry that the hair salon curl up and die is going to poison my well, that is just a generalized fear that is not substantial evidence, right? And so each party's case, whether it's the applicant or anyone in opposition, has to be supported by competent material and substantial evidence. When talking about competent evidence, the statute, and I'm just going to read it, the statute does talk about competent evidence. And it says, the term competent evidence shall, regardless of the lack of a timely objection, not be deemed to include opinion testimony of lay witnesses as to any of the following. And so we'll stop there. You all are probably familiar enough to know lay witness and expert witness, right? An expert qualified under the rules of evidence 702 based upon their training, education, or experience. If they can offer something that is not within the purview of this board, but that can help the board make a decision, such as traffic. That's a great example, right? This board doesn't know anything about impacts of traffic, so expert opinion would be helpful. Noise. This board may not know anything about the effect noise would have on an adjoining property owner. So you may want to get an acoustical consultant to come in and talk to this board about noise, right? That would be what would qualify or what would need expert testimony. You're not going to get Brian Golden, the attorney, up there to say, oh my God, when I can hear a music playing, it bothers me to such an extent that, here's how my property is going to be affected. You're going to need to hear the impact of noise based on someone who has more education, more training, more experience than a lay person.
The
And
cost of that is borne by who?
whoever calls them as a witness. And so if the applicant has a noise expert, they pay it to say, there's not going to be any noise related to the hair salon that's going to affect anybody. The opposition may have an expert that says there's going to be a significant amount of noise from the hair salon that's going to affect everybody. That is the cost that's borne by the party presenting that evidence. And so that goes back to competent evidence. The term competent evidence as used here in the statute shall, regardless of the lack of a timely objection, not be deemed to include opinion, testimony of lay witnesses as to the use of property in a particular way affecting the value of other property. So what that means is a lay witness, such as myself, couldn't get up there and say the use of that property as a hair salon is going to have a negative effect on the value of my property. I'm a lay witness. I don't have any training experience to judge the value of property, but what you would need is an MAI appraiser that says, I've been appraising property for X number of years. I've done 100 impact studies, and I've got the MAI designation, and you all would then determine whether he qualifies, he or she would qualify as an expert, and then they would give their opinion. In my opinion, the impact of the hair salon on adjoining property will be such that there's a negative effect, or it, depreciates the value of the property, or it will keep the property from appreciating at the same rate as other property. I mean, I don't know what they'll say, but that would be. So lay witnesses can't give opinion testimony about how the use of a piece of property will affect other property. They also can't give opinions about the increase in vehicular traffic resulting from a proposed development, what that increase poses, or how that increase poses a danger to the public safety. So again, traffic can't be, issues about traffic and safety would have to be presented by an expert in order for this board to consider it competent evidence. And that's not because I'm telling you that, that's because the legislature has told you that lay opinion testimony related to property values in a particular instance and increase in vehicular traffic posing a danger to the public is not competent evidence. So again, if I get up there and say, oh my God, the increase in traffic to the hair salon poses a huge danger to my kids that, catch the school bus on the road. Can I, as a lay witness, say that? I mean, I can say it, but is it competent evidence sufficient enough for you to base your decision on? And the answer to that, I think, is no. you would have to hear it from a traffic engineer qualified as an expert to say the increase in traffic for the hair salon poses a danger to those individuals who use, Highway 211, including kids who stand there at the corner to catch a school bus. So that is important, right? Because again, the statute requires that you all base your decision on competent material and substantial evidence. So you would have to weigh, is that lay opinion, is it something that is not competent because of the statute, what it says? So again, the quasi judicial hearing is just like a court hearing. And so there will be objections, and you all know this, and you've been through enough of these hearings that someone may object to the relevancy of evidence being presented. The chairperson makes the initial ruling, either sustains or overrules the objection, depending on if you want to hear it or if you don't want to hear it. If the objection is sustained, the other party can say, well, I want the full board to vote on it. And so the full board would get the opportunity to say, yes, we should sustain the objection, or we should overrule it. And that basically is, do you want to hear the testimony or do you not? Is it relevant to what's happening? And so again, that's part of being fair and impartial, giving everyone the process that's due in a quasi-judicial hearing. And so that is another aspect of what you all will do, is make determinations on objections. And so normally when we're going through the quasi-judicial process, it is similar to the protocol that I had, but just quickly to wrap it up, you open your hearing, you have your staff presentation, they give their staff report, which is all just facts. The applicant presents their case. They'll have, the individual maybe who owns the property or who's developing the property, they'll have their experts. They may have some fact witnesses that they want to present. Each time a witness is presented, there's time after that for the opposition to cross-examine that witness. There's time after that for this board to ask any questions that they may have. And so you may have the engineer for the applicant come and say, 20 minutes worth of testimony, there's cross-examination, but let's say you have a question for the engineer that didn't get answered that you think is important. You, board members, have the ability to ask a question. And that comes, normally it would come right after the applicant testifies. Sometimes boards like to reserve their questions till the end, but I think it makes more sense to ask the questions that you would have immediately after the witness testifies. And then the applicant calls all of their witnesses until they rest their case. And then the opposition, however many of them there are, gets to present their case in opposition by calling fact witnesses, expert witnesses, introducing documents for consideration. And again, after each witness, and I will say, witnesses have to be sworn in. I know you know that, but I forgot to mention it, but all witnesses have to be sworn in. So after, the witness presents their evidence, their testimony, cross-examination of every one of those witnesses, questions by the board. And then each party gets an opportunity to rebut, to put on rebuttal evidence if they want to. And again, I don't know how many individual parties will have standing at the upcoming hearing, and I don't know how many attorneys are going to be there in opposition or in support of. But fair trial dictates we give them every opportunity to present their case and confront and cross-examine witnesses. Then once it's all done, rebuttal witnesses are presented. You all can allow for a limited amount of time for closing arguments, which would just be the lawyers getting up there, trying to convince you through legal theories and resuscitation of the facts, why it should be or should not be granted. And a lot of times boards will say, I'm going to give you 5 minutes to make your closing arguments. Because if not, it could go on for hours. But yeah, 3 minutes if that's what you want. You can limit the amount of time because closing arguments is not evidence. It is just a summary of what the evidence they believe, the attorney believes it is. Then it's closed. You close that hearing. You're not taking any more evidence, and then you deliberate. The hardest part of deliberation, and I'll tell you this, is to be able to talk clearly and loudly enough for everyone to hear you. You're not like a jury in the sense that you don't get to go back behind the door and deliberate in secret. You have to deliberate out here. But the reason that you do your introduction and say the board's discretion is limited is so that the individuals know you're not making a decision based on who they are, how popular they are, and whether or not you like them more than anybody else. Your discretion to grant or deny the permit is limited. It's based on the evidence that is presented. It's based on you all weighing that evidence, and you need to do it in an open fashion. And that's important for the chairperson to stress in the introduction that it's not a popularity contest. We are doing what we are tasked to do under the statute in making this decision. And so then you would deliberate, you would make findings of facts. There'll be a proposed motion in order that basically says the use will or will not satisfy this element. The use will or will not satisfy this. And you would go through and make your motions in coming up with whether you're going to grant or deny the application. And so that's in a nutshell, quickly, the process of the quasi-judicial hearings, the evidentiary hearings for a special use permit and a variance and or appeal from a staff decision. The quasi-judicial process is the same for each of those.
You said at one point we could allow people that do not have standing, could allow them to come up and say something. At what point does that happen?
And again, that would be up to you, but it would be my recommendation that would be after all the presentation of evidence from the applicant and all parties withstanding. And if you wanted to allow other individuals to come up and present competent material and substantial evidence, it has to be that. It can't just be generalized fear like, oh my gosh, I'm so worried that the curl up and dye hair salon is going to poison my dog. Right? That's not competent material and substantial evidence. You can limit it to 3 minutes if you want to. You can say any additional witnesses that have non-repetitive evidence that's competent material and substantial. You have 3 minutes to come up and say something.
And do they have to be sworn in as witnesses or can they just come up and speak?
I would probably swear them in because you're building the record and you don't know whether or not it is competent material and substantial evidence, right? And they need to be sworn in, take the oath that they're going to tell the truth, the whole truth, and nothing but the truth.
One of the things that I read in some of the School of Government helping files that we read in our spare time mentions about multiple redundant testimony. Is there a technique that you suggest or something? Well, one of the suggestions was that you might tell anybody who intends on doing that. There's a lot of them on the same. Try to narrow it down to a few individuals with all the facts, but that was one thing.
So that is, again, that is when I represent boards, I find it hard to tell my board, yes, at the end of the presentation of all of the evidence by the applicant and the parties withstanding, allow other people to come forward and testify. Because you will have a significant number of people that may have repetitive testimony. And it may be from groups that aren't related. And so when you want to say, if anybody in this group wants to talk about X issues, you've got 3 minutes to do it. We don't want to hear anything repetitive, I may, and someone else may have the same thing to say. They get to go first. Does that exclude me from saying it? And it could. And so it's, for me, I think if you are a quasi judicial board, you get the evidence presented from those individuals who are parties withstanding. They have shown you that they're going to be affected somehow different than the general public, right? Because if you allow individual witnesses to come up afterwards, you may get someone that says, I just like to vacation here, and the curl up and dye hair salon, takes away my view shed of the place that I rent. So again, you can do it. You can put limits on it. You can say, if you're going to talk about traffic, and there's a group of you that want to talk about it, let's have one person, you get 6 minutes to talk about it, and nobody else from the group. I'm assuming you all have sign-up sheets at the beginning of every meeting. I mean, most boards do. If you don't, that's good. That's fine. You don't have to. A lot of boards will have sign-up sheets to limit the testimony. But you can also say, if John Q. Public gets up there and says something about his view shed, or I don't know, his parking glare, and then Jane Q. Public gets up there and she starts talking about parking and glare, you can say, Ms. Public, I'm sorry, we've already heard that. What you're offering is redundant testimony. Unless you have something else, we're going to ask you to cede the balance of your time. And off she goes. So yes, you as a board, as the chairperson, have the discretion to allow extra folks to come up and testify or not, and you have the ability to limit their time or not, and you have the ability to limit redundant testimony.
I'm not advocating that, I'm just asking.
Yes.
I want everybody to understand that. I'm not trying to limit it.
Right, but again, it's competent material and substantial evidence, and there are individuals who may qualify as parties withstanding. They can call as many lay or fact witnesses as they want, and they can call as many expert witnesses as they want. You're going to get, or you should get, a good sense of all the facts related to any development, any proposed development, if there's opposition.
I have a quick question.
Go
If I
ahead.
may.
Yeah.
So just looking at your outline, I mean, you're noting closing the hearing, moving into deliberation, and a handout that I had actually prepared based on what I was seeing in a school of government training. At least it was a recommendation stating that the board should not close the hearing before moving into deliberations to allow for further questioning. Is it that if the board closes the hearing and they're in deliberations, if they want to ask a question either of staff or of one of the parties, they
Can do.
need to formally reopen it?
Yeah.
Or can they?
So once it's closed, there's no presentation of evidence. There's probably discretion that the board has, but I wouldn't suggest reopening the hearing.
Okay,
And the
yeah,
reason that you close it is so that it's done.
right.
This board would need to ask all of their questions during the time that the evidence is being presented. And so if you sit there as a wallflower and don't ask any questions, and then all of a sudden you close the hearing, and during deliberations, someone says, oh, well, I didn't ask the traffic engineer this, and I should have. Unfortunately, that's going to be something that this board will just have to weigh. If I don't have my answer, you don't have your answer. And so I like to close the hearing before deliberation. That's entirely up to the board. If they think during deliberations they want additional facts and evidence to be presented, then don't close the hearing before your deliberations. But when you're deliberating, you can look at all the documents that were submitted, right? You'll have them in front of you. You'll have the staff report. You'll have all the expert documents. You'll have appraisals. You'll have everything in front of you. You can look through all of those documents. Your time to ask questions is when the witness or after the witness testifies.
I have a question. You defined well quasi judicial hearing. Like a court hearing. That means if we come to a decision, this could be appealed up to the next higher court by somebody.
Oh, absolutely, right? The statute contemplates that every decision by this board can be appealed to the Superior Court of Buncombe County or whatever county the hearing's in. So that's right. It can be appealed. And then from there, that judge sits as an appellate judge. It just looks at the record, and depending on under what scenario the appeal is made, it errors of law, it can substitute its own judgment in place of this board's. But for other matters based upon the whole record, it does not get to substitute its judgment. So it looks at your decision, and if your decision was properly based on any amount of evidence, whether it was just a little bit or a lot, and that evidence was competent, material, and substantial, a Superior Court judge will uphold your decision.
You also said we have the ability to look at all documents, everything that's presented tonight. So none of the documents that either party is going to be available to us before the hearing, correct?
No, so I do not like that, right? Because you have to be fair and impartial. Your mind can't be made up. And if you see a document and you look at it and you study it and you go, oh, wow, I really think that's great. Okay, that alleviates my fear. That's not what you're supposed to come into this hearing with an open mind, be fair to everybody there. And so to get bits of information beforehand may cloud your judgment and prevent you from fairly weighing the evidence that is presented at the hearing. And so, no, you will, if it's my decision, you will not be getting anything early. The attorneys can exchange all the information that they have beforehand. I don't care. You know, if you've got an expert opinion and you say, let's exchange them 5 days before the hearing so I know how to better cross-examine your expert, that's fine. But this board shouldn't have those documents to review beforehand. But that doesn't mean this board can't go out and do a site visit, right? And again, I don't know anything about this special use permit that's coming up. I don't even know where it is. But this board can do a site visit, right? As long as you're not going as a group, you go individually, as long as you're not talking to anybody about it, whether it's the applicant or the neighbor that's in opposition or anything else. You cannot have ex parte communications, and that includes with staff. You can't ask staff, you know, hey, Scott, what do you think of this? Or hey, Alex, what do you think of this? Nothing. You're not talking amongst yourselves about the application. You're not talking to your neighbors about the application. You're not talking to the applicant or the opposition about the application. No ex parte communications. But it might be advisable, and again, I don't know, might be advisable to go out and see the site. But again, don't talk to anybody about it. And the fact is, if you do talk to someone about it, at the part of the, and it's in here.
The ex parte.
Yeah. You have to disclose it.
Yeah.
And then you have to disclose any other conflicts. And that's in C when we talk about ethical considerations.
And so just to sum it up, that means I am assuming we're going to be getting mounds of documents that from these attorneys or witnesses. And so we will have to be reading them and looking at them during the meeting.
Yeah. So what will happen is if I'm an expert and I've got a report on property values, I would testify to it. So I've got this report on property values, ladies and gentlemen of the board. And it says I've looked at 5 comps, and these 5 comps are located here and here and here. And the expert's going to go through his report, and then you all will get a handout. You'll probably get a handout beforehand, so you can follow along with the expert testimony in the handout. And so you'll have then an opportunity during deliberation to to look at it again, to discuss it amongst you when you all are deliberating, not before deliberations. But you'll have it, right? It'll get introduced and testified to, and yeah, so you'll have those documents. How many documents are you gonna get? I don't know. Is it gonna be volumes of them? It might be. Some folks might come and they might have a nice little book, like this book, with tabs that have 1 through 8 and all of the exhibits already labeled, and they'll hand them out. And that when expert number 1 testifies to tab number 1, you turn to tab number 1 and look at it. Then you turn to tab number 2, so hopefully some folks will do that to speed things up as opposed to walking around and right. If they have it all prepared and ready, they can just hand it up to you all. Now, right, you can't look at it until it's introduced, but if it's sitting right there at you, turn to tab 1. Boom, you turn into tab 1. You're following along with the experts saying, or whoever's testifying about that document. So
Got it.
no ex parte communications. Sorry. go
Got
ahead.
a quick question of clarification. So as the planning staff for the town, the actual application and a staff report are considered, that is something that the board
We'll get-
sees ahead of time,
Yeah.
just differentiating, just making sure that
yes,
I'm clarifying.
They'll get, and again, you as a staff technically don't have standing, but you get to participate fully. Your staff report doesn't have any opinions. It's all just
Right,
facts. Here's the
right.
property, here's where it's located, here's what's proposed, here's the application. The applicant has to testify and bring forward, have to persuade the board that all of the things in the application are true, and that it satisfies the elements in their zoning
Right,
ordinance.
Right. I'm really just clarifying from a process standpoint and I guess sharing of information. The application and the staff report are something that are shared with the board in advance, but anything presented by either party or any party is day of. Correct.
The application is just a simple, whatever, 2 or 3 page application that says we propose to prove that we can satisfy element 1 by this, by this, by this. They're not submitting any of those reports. They're not submitting any documents, aerial photographs or anything else that would support it. Stormwater runoff plans. I don't know what they've submitted. But the applicant and the staff report would go probably in the agenda packet. Again,
Right.
I don't know how you all do that,
Okay,
that the board would get beforehand.
right. Just
But
mainly-
that gets testified to you, that gets testified by you, introduced. And the application is just the application. As long as you have deemed it sufficient, statute, your ordinance requires you to move it on to the Board of Adjustment.
Right. Okay.
And so
Just
that's what
clarifying
that's what you're
process.
doing.
Thank you.
All right, so that is, any other questions on quasi judicial? I put in here the oath. Most of the time, boards of adjustment will call everybody up who is going to be a witness, who is a party withstanding, who's going to present testimony. They gather them all around. They say, raise your right hand. Do you solemnly swear to affirm that the evidence you shall give to the board is in this action shall be the truth, the whole truth, nothing but the truth? If so, please say I do. So I've got that written in the script, but that's something that you'll have to do. But a lot of times you may get experts who aren't here at the beginning of the hearing. So you will have to be certain that everyone that testifies, did you already get sworn in? So it's up to you as board members. Do you want to do it individually or as in a group? But definitely everybody has to be sworn in before they give testimony. Yeah, and it's 6 of one, half dozen of the other. Ethical considerations, right? You can't have those ex parte communications. If you do, you have to disclose them. The statute also says there is a conflict of interest in a board member. 9. it would be a conflict for any board member to participate in a quasi judicial decision if the member has a fixed opinion prior to hearing the matter that is not susceptible to change, if they had undisclosed ex parte communications, right? We've already talked about that, or close familial, business, or other associational relationships with an affected person or a financial interest in the outcome of the matter. So if someone gets up there and qualifies as a person with standing, and it is your mother, yes, you would have a conflict. If it was your business partner, you would have a conflict. Or if you owned any financial interest in the property that is proposed for development, I mean, that goes without saying that you would have a conflict. So those are issues that during the ethical consideration of the protocol that I created, we'll have to go through. Has anyone had any undisclosed, or has anyone had any ex parte communications? If so, you have to disclose them. Do you have a fixed opinion? And do you have this close familial, business, or associational relationship with someone who's affected, or do you have a financial stake in the outcome of this case? And then of course, we would then ask all of the parties, the applicant and all of the parties with standing, are they satisfied with the board as constituted? Are you satisfied? Does anyone have any objections to the board as constituted here? And that would be the opportunity for anyone to say, yes, Mr. Jane Q or Mr. John Q. Public is related to the applicant Jane Q. Public, and that's a clear conflict of interest. So then the board takes up that motion to seek recusal of that board member. And I mean, it happens, right? I mean, people are related, have business relationships, associate with folks who may be for or against it. And that may disqualify, that may create a conflict of interest.
What we try to do is at the beginning of each one, we ask the question, does anybody have?
Yeah, absolutely. You would want to, of course, I would interrupt and say, and a conflict is defined as blank, right? But there may be other reasons that there is a conflict. Maybe you don't have an associational relationship with one of the opposition parties or the applicant, but they, I don't know, you didn't like them as a kid. They beat up your son. If you've got a fixed opinion about that person, maybe they lied to you as a young adult. You just can't get that out of your head. You would want to disclose it, to say, yeah, I might have a fixed opinion. If John over there is going to testify, I don't believe him. I'm never going to believe him. He's lied to me 100 times. I've got a fixed opinion. I'm going to have to recuse myself. I mean, that, it's a bad example, but it gets to the point. You'd want to ensure that people know what a conflict is, what they have to do to avoid those conflicts, and what they have to disclose before the applicant and any party with standing can determine if the board as constituted is proper. Anything else? Because we're going to finish up strong on the special use permit. I got about 10 minutes.
That's okay.
So as I understand it, this is a special use permit that's coming up. So I focused on that. So we're not going to go over any of the variance standards that would be necessary to grant a variance. It's just the special use permit. And your zoning ordinance lays out several factors in chapter 310.6. And it talks about the standards that need to be proven And so this board, when it is creating this record, letting evidence be presented, it is doing that all with an eye towards the particular factors. There are 6 of them, 1, 2, 3, 4, 5, 6 factors that will need to be proven. And generically speaking, here's what they are: that the use will or will not be detrimental, right? So if the applicant is trying to prove, is trying to persuade this board to grant the application, they will have to show that the use is not detrimental to the public health, safety, and general welfare, if developed as proposed. They will have to show that the use does or will meet development standards. The applicant will have to show that it does not, the use, if developed as proposed, does not substantially diminish or impair the value of property within 250 feet of the proposed use. And it actually says 250 feet of the boundary of the parcel on which the use will be located. If they want it to be approved, they will have to show that it is in conformity, or no, strike that, that it is in harmony with, and what does your ordinance say? It says that it will be in harmony with the area in which it is to be located and will not be injurious to the use and enjoyment of other property, right? And so harmony, there is a particular case out there. Oh, golly day. It is the Humane Society case. Basically says that if a particular use is set out in an ordinance as permitted with a special use permit, that it is deemed to be in harmony, unless, of course, there is contrary evidence that shows that it is not in harmony, right? So if no one speaks of harmony at all, if no one says anything about harmony, because it is listed in the town of Montreat's zoning ordinance as a permitted use by way of a special use permit, this board can deem that use to be in harmony with the surrounding area. But it says it has to be in harmony with the area in which is to be located and will not be injurious to the use and enjoyment of other property. So it's right, it's this 2-part standard. You might be able to find that it's in harmony, but you might say, oh my gosh, that curl up and dye hair salon is definitely injurious to the use and enjoyment of other property that is around it, and which for the purposes which are already permitted. So again, it's part of the deliberation process, but that is a element, a standard which has to be proven, which has to be proven by the applicant for this board to grant the special use permit. Also, it goes on, and another element, if it needs to be, if the applicant wants to have this board approved, is that the location and character of the use will be in general conformity with the adopted policies and plans, including the comprehensive plan of the town of Montreat. I think that's what we talked about a little bit earlier. It is, they just have to satisfy that element, that it is in conformity with those adopted policies. And then the last one, and it's important, says that adequate measures have been or will be taken to provide ingress and egress, so designed as to minimize congestion in the public streets. But when you're talking about ingress and egress and congestion in the public streets, remember, the statute says competent evidence is not lay opinion testimony of increase in traffic and posing a danger. So this doesn't talk about posing a danger. It just talks about ingress and egress to minimize congestion. But if someone's going to get up there and say the increase in traffic poses a danger, right? So the ingress and egress is going to pose a danger to the health and safety of people working in that area. That would need to be presented, I would contend, by an expert. If it was just lay opinion, if it was John Q. Public getting up there saying that, and he wasn't qualified as an expert, it wouldn't be deemed competent. But again, that's an important standard that this board will have to look at. So those 6 standards are there. And as I said, if the applicant persuades you that they have met all of those, they have satisfied all of those elements, they would be entitled to the permit. Unless, of course, the opposition gets up there and presents contrary evidence, material, substantial, and competent, contrary evidence, then you all have to weigh it, right? You have to just balance the evidence to determine which one's more credible, which one's not, it's the quality, not the quantity of evidence. You just really have to focus in on it. You have to say, well, I trust this one more because of blank, or I really don't trust this one because of the bias or whatever. And so those are in particular, this board looking at a special use permit, anyone has to satisfy those elements. Now, of course, the applicant doesn't have to anticipate every idea that comes up, as far as if the opposition presents some outlandish idea or presents some kind of evidence that the applicant didn't think of. That the applicant doesn't have to disprove everything. What their burden is to persuade you that they've satisfied these elements, right? And your statute goes on, strike that, your ordinance goes on, and it talks about the burden. The burden of persuasion, of course, is on the applicant. The burden of presenting a complete application to the board is on the applicant. It's only a complete application as determined by staff that sends it on to you all. And so in 310.6.36 or 5, 6, and 7, the burden of persuasion on the issue of whether the development will comply with the requirements of the ordinance remains at all times on the applicant. So the applicant has this big burden, like Sisyphus, to push this big stone up the hill. But unlike Sisyphus, once it gets to the top, it doesn't roll back down. But it might, right? That just all depends on the opposition testimony. So they've got a heavy lift to begin with to satisfy all of those terms or all of those elements. But that's what's important with this board considering a special use permit, is to follow those elements.
Is it up to the applicant if the property are located within the 250 feet, or is that something the town? And are we supposed to go out, okay, this one or that one?
Right, and that is, and that's an excellent question, because that is the oddest element that I've ever seen, to limit, to say that the use will not substantially diminish and impair the value of any property, any portion of which is located within 250 feet of the boundary. That's an excellent question. I suspect the applicant's going to come forward and present evidence that these properties, they're going to do it by an appraiser, these properties or any portion are located within 250 feet of the boundary of the proposed development. And the appraiser is going to get up there and say there will be, I'm assuming, I'm speculating. The appraiser would get up there and say
that the applicant is the one to say, this is the list of properties that are within the 250 foot boundary,
yes.
not the town. Town, it's
The-
not.
The town could,
Staff.
because as a fact, there are certain properties within 250 feet, right? So the town could give a listing to this board of the properties that are within 250 feet. That's just a fact, right? So yes, the town could do it. It's not that that's not what's important. The applicant has to prove that there's going to be no negative or injurious effect on those properties.
Is that 250 foot boundary also the property, the standard for someone with the standing? When we were talking about people that have adjacent, that are
Right, so
adjacent
this-
property, is this?
No, that's
250?
not that's
That's
so right.
not
It's proximity, right? You're looking at proximity.
Okay.
But that in and of itself isn't sufficient to grant standing. And so somebody within 250 feet that alone isn't sufficient for standing.
Yes.
So, but that is an element. This board
is an
could
element.
consider 250 feet as being in close enough proximity that if they can show an injurious effect on the value of the property based upon traffic, vandalism, odor, glare, stormwater runoff, then they could have standing. But again, 250 feet isn't the magic number. Somebody could be 500 feet away
Okay.
and have a more significant impact.
Okay, that's what I want.
yeah.
Also, the comprehensive plan of the town of Montreat, is that something that will be provided? Or is that something we need to look at ahead of time?
That will be provided.
Yeah, and again, that burden to prove that is on the applicant, right? That one of the elements that the location and character of the use, if developed according to the plan, will be in conformity with the adopted policies and plans, including the comprehensive plan. And that goes back to if you're talking about the comprehensive plan, it doesn't say adopted policies and plan. I mean, I'm trying to think what would be an adopted policy that the town would have that you could try to prove. You don't have to prove that the use satisfies every adopted policy, right? And so if there was a policy in the town that said all cars have to be green, all cars have to be green, and the applicant couldn't prove that all cars were going to be green, if there was no evidence presented from the opposition that all cars weren't going to be green, does the applicant really have to prove that? No, because it's just a non-essential issue, right? And so that is what I was talking about. There's a particular case that says the applicant doesn't have to anticipate every bit of evidence that the opposition is going to present. But if they do present the fact that all cars aren't going to be green, the applicant has the ability to rebut it and say, aha, we only sell green paint, and of course all cars are going to be green. I mean, I don't know what they'd say, but right. So they've got the ability to rebut it if it's brought up. And I wonder if I've got that case real quick so I can just read it, what it says. Yeah, so the case of Little River LLC versus Lee County, a 2017 case. And it does say the applicant need not negate every possible objection to the proposed use. And so if there is, again, an objection that says, your cars aren't all going to be green, if that's important, then they have to, then the applicant would have to disprove it. But if it's not, right, if that's just a random objection that someone brings up, there's no need for anybody to disprove it. The elements that the applicant will focus on are what satisfies those 6 items listed in your zoning ordinance.
The last question I have is about the harmony part. Is
Yeah.
that where aesthetics come into play when someone says, I know aesthetics
If
not
a
supposed to be one of the issues, but you're getting into the people are going to come up and say, it's too big. It doesn't look like the rest of the things that are out here. Is that considered harmony?
So I don't speculate on what people are going to say, or what you think they might say. Harmony is really what it is. You're looking at the neighborhood, the surrounding properties. You're looking at properties maybe within 250 feet. Maybe you're looking at them all within a particular subdivision. And if they're all brick ranch houses, and then somebody wants to come in and build a concrete structure that stands straight up, is that, it might be allowed and they could do it, but is it in harmony? That's something you'll have to look at. Maybe they'll say, oh, well, it's white and all of the brick ranches are painted white, and it's got the similar roof or so. Yeah, harmony.
That would be harmony.
It is that is harmony. It is if you're putting a metal structure in an area that is predominantly wood-sided. Is that in harmony? I mean, there's a lot more that goes on to it than aesthetics. And like I said, there's that particular case that says that inclusion of a use as a special use in a particular zone establishes a prima facie case that the use is in harmony with the zoning plan. And so, again, I don't know what the evidence is going to be for or against the application. Size may be an element of harmony. Aesthetics may be an element of harmony, but maybe not. I mean, that's going to be entirely up to this board. And this board, you know, may want to hear evidence about something further on down the road. What else is in the, you had said it's in the IR district. What other uses in the area are in the IR district, right? I mean, that's a question this board can ask. If the board has to determine harmony and it needs an answer to one of those questions, ask it. You know, what other uses in the IR district? What other kinds of buildings? If in my example with the brick ranches and the steel or the concrete monolith is the only one different, but the next neighborhood over, there are all of those structures, it might be in harmony, right? Not with that subdivision, but with the surrounding uses in that zoning district. Again, and I'm sorry, I should have familiarized me, but I don't know where it's going to be located. And I've looked at the application, but it wasn't in detail. So, you know, we're not speculating here about what is going to be presented and what's not going to be presented. All I'm saying is that is an element that has to be proven, and you can ask questions about it.
That's how you get paid the big bucks.
That would be it. I think, you know, you all have an understanding of what your elements are, what has to be proven. If they are, if the applicant persuades you that they've satisfied all those elements, they would be entitled to the permit, right? Again, unless contrary evidence is presented by the opposition, substantial material and competent evidence. And then this board, and it doesn't have to disprove every one of the elements. I mean, if the opposition focuses on just a particular one, let's just say property values, and you find that the evidence presented was credible, more credible than the applicant's evidence, you could find in favor of all 5 of the elements, and then the 6th element not find in favor of, and you would deny the application. So yeah, that is it. That is important. Open trial, fair, impartial. You all are impartial. Swear all your witnesses, no conflicts of interest. We'll rock through who gets standing. We'll swear these witnesses in, present the testimony, look at the exhibits, continue the hearing if it lasts longer than 5 hours. Yeah. And we've only been, I don't even, it's 9 o'clock. Is that what it says? We've only been here 2. Yeah. Right. We started at 7, right? So we've only been here 2 hours, and you guys put a 5-hour time limit on it. Woo. So, any questions on the special use permit? On the process, on what you all, you know, the aspect is you all are having a quasi judicial hearing to entertain a special use permit, but it could be anything else, a variance or an appeal from a staff decision. Anything? Anyone? Yeah.
Conditional zoning. What is conditional zoning?
Not this. Conditional zoning is, right,
Good answer.
yeah. Yeah. You're welcome. I will say conditional zoning is a legislative process different than an evidentiary hearing. Legislative processes have a lot of ex parte communication, but it is not this. You all have to cannot have ex parte communications with anybody related to this case. So that's why we're just training. Anything else? That was it. That's a wrap for me. And I think there's still a couple of things on the agenda, which would be to adjourn.
Yeah, thank you. Thank you so much. It's very helpful. We do have, as part of our normal process, we won't limit it. Let's try to not, but we will open up if folks have questions. The reason we did this, as a matter of fact, I think it's wonderful, great for Zoom, because if people want to apply for things that are lay people, they may not know. I think this is a good training, not just for us, but folks in the community. That's the goal. So,
Right, I forgot public comment. You guys have that down there at the bottom.
yeah, that's right. So I'd like to open it up if anybody has any questions or comments that they'd like to make. From the, yes, sir.
On page 2 of the handout, it lists in the middle, at discretion of the city or county, jurisdictions can specify planning staff, 1 makes a recommendation, or 2 only presents facts. Says, and so says it's silent on this.
Yes, that's my, so I put this handout together just based on some, it's really, it's a highlight, or it's several highlights from 2 UNC School of Government trainings that the board was requested to review previous to this. And this was simply my note looking at the Montreat zoning ordinance, that there is no explicit language for the planning staff to give a recommendation in relation to a special use permit. So my reading of the ordinance, in the absence of anything stating give a recommendation or not, is to simply state facts.
No, could we get a copy of the handout that the board got?
I
Y'all
can-
covered a lot of ground tonight. And
I can, yes, I can share that. I think I've got a good number of folks' email addresses, but if you want to just email zoning@townofmontreat.org, anybody listening or watching or otherwise, I can share all that.
Anything else? Well, I believe we appreciate everybody showing up and going to do our best. This is a continuing education process for us. But we're glad that everybody got to participate in it. See where we are, who we are, what we're doing. We're your neighbors. So the last thing is, board got any questions? If not, the last thing on there. That's exactly the question I was going to ask. Do I hear a motion to adjourn?